All right, welcome everybody. Good morning, good morning, good morning. And I thought, you know what, we're in day 4 of this trial, and I thought it's, it's well time that I come and say hello, especially since we uh, have a little bit of a break and a delay. Now, today, guys, I want you to remember that we're only going to be on it, and again, it's already starting late. So the court is scheduled to end at 12 today. That's what they said on Friday. So this is going to be an extremely short day for this case. Tell you what, between New Hampshire and California, talk about two inefficient court systems to come up with more delays than you can count on count on one finger or count on one hand. It's ridiculous. Um, but this case, the judge is expecting that this case will be to the jury by the end of the week. That's what he said previously in some of the off the record moments when he was talking about scheduling with um, some of the parties. So let's talk about what we've got so far in this case. What is this case about? So this case, self-defense case, it's one I like. It reminds me a lot of the John DeLee case. That was a New Hampshire case. It's one of the first ones I covered. I did extensive coverage of it. Did a breakdown of all the security cameras. Now it's a little different, but it's almost the same in a couple aspects. It's different from the standpoint of how everything went down. The John DeLee case was a situation that escalated at a bar. There was a group component to it. What's similar to it is the multiple shots fired and how a New Hampshire jury handled that in that case. And that jury found John DeLee guilty of everything. Now, here's the thing: John DeLee was an aggressor in that in the sense that there was video of him being an aggressor earlier in the evening. There was just a dispute at the bar, so a lot of factors don't necessarily match up with this case. Now, in this case, what we have is a long-standing dispute between two individuals, and we have a very interesting concept here. And the concept that the defense is putting to this jury is in New Hampshire has a stand your ground law. So what we're seeing play out here is whether or not the threat that was allegedly made by Kyle Violette, and we're going to be hearing from him, I believe, it might not be today. He might get started today, but we're going to hear from him in this case. And whether or not that threat and him saying, I'm going to kill your family, the defense says he doesn't have to wait till he shows back up with a gun. He doesn't have to wait till he shows up with a weapon. And he boom, 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 boom. Now, 6 shots were fired. Or no, 5 shots were fired. 5 or 6 shots were fired. I think it was 5 shots were fired at him. 1 shot was fired to the face. 5 more while he's crawling away on the ground. So the state in this position is saying, hey, Mr. Violette is, was retreating and he was being shot. Therefore, it mitigates or gets rid of self-defense. And also, one common argument is made is that self-defense might have been in the first shot, but once he shot him additional times, it doesn't carry over. So in this case, the jury's going to have a hard question, and that's going to be how do they look upon the fact that Violette was not at all armed, and that this is talking about a threat that was potentially going to be followed through on, and that if Jason Levesque thought that that was going to be followed through on, if he had a belief, since he was threatening not just him but his family, he has a right to defend himself. And in New Hampshire, Violette came over to him. He's threatening him. Going back in the house. He said, "I'm going to kill you if any of this snow gets on my property." And he shoots him to prevent him from going in to retrieve a weapon to come in and kill him and his family and his daughter. Um, I see this being mitigated out of a manslaughter situation or attempted manslaughter. It's not, it's attempted. He was not actually killed. I think there's going to be some sort of a lesser conviction here because of the the amount of shots that were fired, but it's going to be interesting. Um, so it's going to come down, of course, to how the jury receives Violet's testimony and um, how they receive the testimony of Jason Levesque, because he's going to testify in this case as well about what his perceptions was. Now, you have to understand, these cases are somewhat complicated at least in the way a jury is supposed to view it, is you can't allow it to be viewed from your own personal perspective. You have to view it from the point of view of the individual in the moment at that time, what he saw, what he heard, what he felt. And if he felt that there was a real threat in front of him, he had a right to act under New Hampshire law, and it would be deemed self-defense. Obviously, it's a hard sell when you have 6 shots. Now, I don't know if the defense is going to go here where I thought they should have gone with in DeLee's case, and that is the idea that when you're feeling threatened, it is very common that somebody, when they fire multiple shots. And although there was a small delay there, whether that was a perceivable delay to him or not, and he was just firing because it was like, he's going to go get his gun, he's going to kill my family. Bam, 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 bam. You need a self-defense expert. And I know this only because I remember talking with the DeLee case with my dad. He was watching it with me. I remember him being involved in similar cases, and that was exactly what he did. He called a self-defense expert. Commonly, it will be a former police officer who will testify, familiar with the laws of the state, familiar with how these things happen, and they'll talk about that state of mind that they get into. You can also call even a psychologist that says when a person gets in that mindset where they're threatened and they're firing a weapon, even though it's, to the outside individual Monday morning quarterbacking the shooting, it looks really bad, right? 5 shots or 6 shots in this case. But it can all still be it can all be part of the perceived threat, and can be part of just where an individual starts to fire and they're just firing. They're firing out of fear. They're not firing with the intent with malice. They're not firing and it's a true concept. Obviously, it's a matter of resources. It's a matter of what the defense can afford to bring. Can they afford that expert to come in, and will the judge allow them to do it? Because I don't know if he's paying for this himself. He might be. If he is, then maybe we're going to see that testimony come in to explain those 5 shots, 6 shots, because that's going to be a part of the case here. That's going to be extremely damaging to Levesque. Now, I think a significant part to me so far has been it was Miss LaChance. She was on the stand and she testifies. Defense brought it out that she was warning him, don't go out and do something stupid. She was letting him. She essentially was asserting that this was something that was brought upon by Violette, not Levesque. Clearly, Levesque coming home from a 24-hour shift. He's on his own property. He's minding his own business, and this guy walks over and starts threatening him. So to me, that alone says this should not be at the highest level. This should not be, the big M or attempted big M. So if I was sitting on this jury, I don't think I would be wanting to go to the top on this because of the fact that guy walks over to the property. He's making active threats. He's yelling at him. He's starting this altercation. Now, again, does that mean, though, that you should shoot the guy in the face and shoot him 5 more times? Well, again, that's what we're here for, and that's what the jury's ultimately here for. So, really interesting case. This will, like I said, be a short day. It looks like they're in court right now. I'm watching. The court's not on. They're waiting. Levesque has been brought in the courtroom, and he is being held without bond in the case. Even though you're seeing him walk in and out, he's actually got 2 court bailiffs that are dressed in, I guess you'd say, plain clothes that are flanking him. It's kind of interesting. It's really nice. Oh, we're in court. Let's jump in here.
All right, so for the record, we are back here on this matter of the state of New Hampshire versus Jason Levesque. This is 2024 CR 273. As I discussed earlier, because we're not having testimony at this point, I thought it was a good opportunity for us to address the various motions that were filed by the defense over the weekend. Oh, before we do that, though, counsel, I should let you know I have copies of my proposed jury instructions, which I did over the weekend, for you all. You're welcome. Do you have any? I have 3 sets there. So we should still have plenty of time that you'll have a chance to review those and get back to me. I have included, just so you know, I included the long form self-defense standard instruction. You know, there's a short form and sort of a long form. I've included the long form self-defense instruction, which was my plan all along. So that basically matches, I think, what the defense was asking for in their proposed jury instruction. To the extent, Attorney Sisti, that there's anything, I think I've captured everything you asked for in your proposed jury instruction. To the extent that there's something different, obviously you're free to raise that. I did also include language about not only self-defense but defense of other, because I do think you have raised some enough facts that should go to the jury as well. So I've crafted it, but if the state wants to object to that, I will hear from you. And if you need time to think about those things. The other thing I did that's unusual in my jury instructions is, you know, there's a standard jury instruction for prior inconsistent statements, and that prior inconsistent statements don't come in for the truth of the matter asserted, but they're only used to assess the credibility of the witness. I've chosen at this point, and I'll hear from you at some point about this, to eliminate that, because there really have not been any prior inconsistent statements that I'm aware of that have been used to impeach anybody in this case. And the only prior statements that have come in were the prior statements that the state put in as substantive evidence under the rule of evidence for prior recollections recorded. So I think it would be confusing to the jury if I gave them that standard instruction, which says basically you're not to consider out-of-court statements for the truth of the matter, when in fact there are some out-of-court statements that they can consider for the truth of the matter. So I think it's actually better just to not discuss prior statements at all and leave it open. But that, I just want to highlight that to both of your attention, because that is one change from the standard instructions that I did in these. Otherwise, they basically follow the standard instructions, but feel free to let me know if you have any concerns. All right. So that leaves 3 other motions we're going to take up at this point, and I think it makes sense logically to start with the motion for a mistrial. So I've reviewed the defense's motion for mistrial. I fully understand that the state has not had an opportunity to file a written response, given your computer issues. If at some point you feel the need to file a written response, let me know, but I think at this point we'll go by oral arguments. Attorney Sisti, it is your motion. I'll hear from you first.
Thank you, Your Honor. And, you know, there's a little bit of background here. This issue, or these issues, really didn't rise until Friday afternoon. And around 2:30 in the afternoon, it was announced at the bench, on the record, that Violette would not be testifying in this matter. And I can assert, and I'm sure the state will agree, that that is a development that was not anticipated. That certainly was not in play on the 3rd of this month when we were selecting a jury. And it wasn't in play when the court had contemplated preliminary instructions with the jury. I can say that voir dire on the defendant's part was framed around the assumption that the alleged victim in this matter would be testifying. And in fact, that assumption would have been buttressed certainly by the voir dire of the state with the potential panel as well. I think both the state and the defense were raising issues with the panel in expectation of Mr. Violette taking the stand.
Counsel, maybe you can fill that out for me a little bit, because I read that in your motion and I was a little, I wouldn't say puzzled, that's a very too strong a word, but I was curious as to how you would have voir dired the jury differently if you had known from the outset that Mr. Violette might not testify. What sorts of questions would you have asked, and what sort of bias or would you have tried to ferret out from the members of the jury that you don't think you were able to?
Yeah, we would have actually gotten into what I have proposed as a missing witness instruction with the court. And we would have delved into their belief on that particular issue. Some people would take that and embrace it. Some people may not have been able to follow that instruction. We don't know. At this point in time. But it would have been something that would have had to have been raised, because maybe we should get into this a little bit deeper. When that is joined with a self-defense instruction, the voir dire is quite different than me trying to delve into them, trying to judge the credibility of witnesses. They would not have to judge the credibility of Kyle Violette. In fact, they would have a presumption, or they would have the inference that his testimony, in fact, if he testified, would have been unfavorable to the prosecution.
Right, but that only works if the court were inclined to grant the missing witness instruction in this case. And that's so I see how these issues are all sort of intertwined.
Yes. No, I understand that. I mean, although there's a difference between the missing witness instruction and the missing witness argument. The argument can be made without the judge's, without the court's instruction. There can be argument with regard to why isn't he here? He's the alleged victim. There's no good excuse for him not to be here. That can be covered without the instruction.
Courts have allowed that. Courts have certainly allowed that.
Correct.
With the caveat that you can't ask the jury to speculate about things that aren't in evidence.
Right.
But I can carry on.
But the problem is, we weren't able to get into it. And I don't know what the rules of the game were during the course of voir dire. And quite frankly, neither did the state.
Right.
I mean, neither did the judge. I mean, we were all sitting here.
Right, but to the extent that that's an issue, you can raise it in your closing, right? I mean, how?
No. I can't re-qualify a jury on closing. All right. I can't re-strike a potential juror on closing. I can't move for a cause on a juror on closing. I mean, that's what voir dire is about. Mm-hmm. That's what jury selection is about. And that's why we're given and afforded the opportunity to question during the course of voir dire, and that is to vet out the issues that are expected at trial. This is a totally unexpected development. Totally unexpected development. And in fact, on the third, I mean, I looked at the note, and part of my question had to do with the intensity of the contact, with in fact, the initial aggressor aspects, the fact that they have to look at the credibility of the testimony of everybody. And then that was reasserted on the 12th, on the opening, where the prosecution asserted he was the victim on their opening. Right? Certain words that he would be saying, their version of what the words would have been on opening, which, by the way, he's never going to be able to testify to.
Well, my memory is, and I'll let the state talk about this, my memory was that in their opening, they almost, and I was struck by this, the state never used the sort of standard language you hear in openings, like, you are going to hear from Mr. Violette and Mr. Violette. At least my memory is, I don't recall the state making statements like, you're going to hear from Mr. Violette and Mr. Violette is going to tell you X, Y, Z, which, frankly, the court took as a hint, probably too strong a word, but a suggestion that the state, in opening, wasn't certain that Mr. Violette was going to be available to testify as a witness in this case, and I'm sure that you must have been struck by that too, the fact that the state never once in their opening said that sort of language that prosecutors routinely say. I could be wrong about that. I'm just going by my memory of the openings.
Well, my note indicated that some of it was, if you leave fucking snow in front of my fucking house, I'll kill you.
Right, but that came in, but that's coming in from the defendant. I thought that they were saying that that's what you were going to hear, that the defendant said that he said.
And I am stating to you that would have been a statement from Violette.
He testified, right.
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 And there would have been more. But,
Presumably.
right. And frankly, that's where we were going with this, is that it's not just there, that there's intensity, that there are core issues in the case, that credibility is one of them. In fact, there was an objection raised by the state on the credibility issue when I said that Violette wasn't straight with the prosecution, he wasn't straight with the police, and that was raised and that was argued at the bench, and in fact that was a withdrawn part of the opening. By the way, I anticipated that if he did take the stand, all right, that he minimized this particular event. He would have had an interview, I think it was on May 29th of 2024 with the police. In fact, one of them would have been Detective Danny looking on in the CAC room, where Violette basically said, "Oh, I was just going out there. I didn't want a confrontation." I mean, I'll make that offer of proof to you right now. That those are basically the words that he was urging the state or the prosecution to embrace, which are completely false. All right? And these are the areas that we were setting up and getting ready to deal with him on.
Mm-hmm.
Okay. Now, these aren't small things. I mean, he's a big player here.
Oh, I agree.
Right. I mean, he's the alleged victim in a case. There has been, as the court just noted about 10 minutes ago, there's been evidence adduced at this trial where a self-defense deadly force instruction is going to be read to the jury, not only protection of himself, protection of his daughter in this case. So that end of it's in.
Mm-hmm.
The question is, if you join that for purposes of the motion to dismiss, and I have to jump back and forth, I'm sorry.
Understood.
If you join that with a missing witness instruction, the state's case is gone. It can't sustain itself if the alleged victim's testimony would be presumed or inferred to be unfavorable to the state's theory of prosecution. And there's a self-defense instruction. If you put the two of them together, it doesn't even make it across the hurdle of a motion to dismiss at the end of the state's case. It certainly doesn't make it past the hurdle at the end of all the evidence. The case can't go to the jury at that point. I mean, what's the issue? What is the issue at that point?
Well, I mean, setting aside the missing witness problem, the missing witness instruction, if it was the mere fact that the witness is not available and that you've raised self-defense surely can't mean that the state can't meet its burden. Otherwise, you could never pursue a homicide case when self-defense is raised. Clearly, the state can meet its burden overcoming self-defense, even though the victim isn't available to testify.
No, I disagree vehemently with that statement. In fact, that's the difference between a missing witness and a deceased individual, because that individual is deceased. With a missing witness, that means that the witness in this instruction, there is a comment by the court where that individual, if that individual were to testify, all right, his testimony would be unfavorable. With a deceased individual, of course, you can't get a missing witness.
Right, so again, that's only if I give you the missing witness instruction.
And I'm arguing off the basis of the missing witness instruction.
Okay, maybe we should start. Maybe we'll have to start with that. I mean, if that's. I was trying not to do all three motions at once, but we may inadvertently end up doing all three motions at once. If you want us to try to disentangle them or be heard more, I'm happy to do this however you want. But the missing witness instruction is tricky because, I mean, I think the case law is pretty clear. If you look at Ramos, I'm looking at State v. Ramos, 121 New Hampshire 863. It's a 1981 case where the Supreme Court held that the court should not give a missing witness instruction where the witness is equally unavailable to both sides. And my understanding from the offer of proof that the state made, and maybe we need to get into this at some point, as to what the level of proof needs to be on this question, and whether there needs to be more than offers of proof or some sort of testimony. My understanding from the state's offer of proof previously was that the witness is unavailable to testify because he is simply not in an emotional state to testify. And it's basically, it's akin to a form of illness, right? He's unavailable because he cannot testify, despite their efforts to get him to testify. And when this court asked whether the defense intended to call this witness who was under subpoena, you informed the court at that point that you did not intend to call him as a witness yourself because of what the state had alleged, which was that he's not well enough to testify.
Let me clarify myself. One, I'm very familiar with Ramos's case.
Okay.
Right? That was one of our initial cases in Manchester when we started. And I'm extremely familiar with Ramos.
Okay.
This is a completely different situation. Completely different situation.
Okay.
This is a witness that is aligned and would be more favorably tending to deal with the prosecution. In other words, this is a person who, in fact, the state's theory of prosecution is based on. One. Two, he is certainly more available and in contact with the prosecution than we ever could be. All right? And that's part of the test, by the way. All right? Part of the test is whether or not there's an affiliation with one party over the other. It's pretty clear there is. In fact, the First Circuit instruction is if it's peculiarly within the power of the government to produce a witness who would give material testimony, or if the witness would be favorably disposed to the government. Of course it's going to be favorably disposed to the government. Failure to call that witness may justify an inference that his testimony would be unfavorable to the government. I mean, this is a simple test in this case.
That's the First Circuit's test, yes.
I mean, we're in the First Circuit, and you know, it's the due process area, and that's an issue that's alive and running right now. But I also have to say, I don't agree with offers of proof on his unavailability, so I think we should take that off the table right now. There's been no proof as far as I'm concerned that he's unavailable, other than he's not being called. And that's what the facts of the situation are. I'm not going to call him. He's more predisposed for the state. At this juncture, he is the poster boy for their prosecution. He is it. All right. Now, I mean, the true test is, well, if you look at any of the other states, in fact, just the Commonwealth of Massachusetts. It's the same test as what I just read from the First Circuit. If he's more affiliated with one party over the other, then boom, there you go. And by the way, again, you have to be really careful about why don't I call him? Well, we don't have a burden of proof, and that's also announced in all the cases.
Understood. I know that.
So, I mean, that argument means nothing. And the fact, by the way, that he's under subpoena, that means nothing. I mean, those all wash out in the case law if you look through it. The real question is, who's he affiliated with? Who does he identify with? Okay? Who has more control over him? I would suggest the prosecution does, the victim advocate does, certainly not SISP law offices, and certainly not Mr. Levesque. Okay?
Understood.
There's an actual hatred there. So,
but do you have a single case that you cited? I haven't seen one. I haven't found one myself where the court has given a missing witness instruction when a victim was, for example, sick, unavailable because they were ill. Do you have a single case where a court has given a missing witness instruction in circumstances like this, where it's not just that he's not here, but the representation being made by the state is that he's emotionally, psychologically unable to testify?
Well, you know, maybe we should have known that before we started the trial, Judge. I didn't know it was such an acute situation, and I don't have one psychiatric report in front of me to sustain that particular conclusion. And I don't think the court can come to that conclusion without competent medical, psychiatric evidence before it, a full hearing on that particular issue, and not an offer of proof. And also, if he was suffering from that at the beginning of this trial, don't you think we should have known about that? Don't you think that that's something that the defense should have known and that we should have been able to ask the court in a Gagney-type motion to review just what is going on with him so that we can confidently cross-examine him at the time of trial when he is called to the stand, anticipated to be called to the stand? I mean, those are the other issues. If in fact they were of knowledge that he was having a problem before 2:30 on Friday, we should have been notified of that.
Okay.
I would have had a motion in there asking for that. Okay, before he was cross-examined.
So I know I've taken you off track, and I apologize for we've jumped around on issues, and I've sort of peppered you with questions. But so if you want to go back, I mean, we started with the motion for mistrial,
Right.
which I think I understand your position, which is that if you had known the witness would not be available, you would have done voir dire differently, you would have opened differently, you would have prepared jurors for the idea of the missing witness and the missing witness instruction, probably would have been talked about earlier, etc. Is there anything you want to add to that?
Yeah, on that as well, and if he was suffering from some condition, all right, that we should have been notified of that as well.
Okay.
Okay.
Fair.
So none of that's there.
The motion to dismiss, I mean, it's a little premature. I understand where you're going. You're arguing that between self-defense, if you combine the self-defense instruction with the missing witness aspect and the inference that the jury is allowed to draw for the missing witness, and your position is the state can't meet its burden in this case.
Right. And I want to be clear because I don't want any misperceptions. A missing witness instruction can't apply to your normal homicide case.
No, right. I understand that.
And I don't want to get off base here because I think we should all understand that that would be an impossibility.
No, of course. And I prefaced my question by saying, setting aside the missing witness problem,
Right.
the mere fact that you don't, the missing witness instruction, the mere fact that you don't have a victim who can explain what happened doesn't mean the state can't meet its burden of overcoming self-defense.
I would say
on its face.
In extraordinary circumstances, that may be true.
Well, in every homicide case where self-defense is raised.
Oh, yeah.
Right. I mean, in every homicide case where self-defense is raised, the state has to meet its burden of disproving self-defense without the person who can give that side of what happened. And that happens all the time.
That's a given.
But your argument is when you add the missing witness instruction and the inference which the jury is permitted to draw, but not required to draw, the inference they're permitted to draw, then you think it prevents them from getting over the hurdle of
Yeah, that's a problem, and it's also a subject of, I'm going back to the beginning again.
Mm-hmm.
That's something that would have been addressed on voir dire, and that's something that would have been addressed on open. Right? That inference, how it impacts, and what we would strive them to do if we get to that point at the end of the case.
Okay.
So, I mean, we're left without that ammunition. We're left without that. And, I mean, I don't know what the timing's about.
I'm sorry?
I've worked with Chuck forever, all right? In federal court, county court, public defender. I don't think he's high on the ball. I mean, I'm sure Sarah's not either. But, I mean, that's something that came up and kind of snuck up and bit us all on Friday afternoon. And it's difficult for me now to replay all the things I would have done knowing that, but there would have been a lot. I mean, the Gagney motion itself would have been filed immediately if we knew there was a problem. Okay? I mean, I would have been rightfully asking for his mental health records, or at least to have them submitted to you so that we could know whether or not there was relevant material in there to probably deal with two issues. One, his credibility, and two, what we're arguing about right now.
I may have misspoken. I didn't mean to imply that the court has reason to think that the complaining witness in this case is undergoing any mental health or psychiatric treatment. I have no way of knowing. I just was given the offer of proof from the state's counsel that he was emotionally not able to participate in the trial. But I'll hear from the state. I'm sure they'll clarify all that.
No, actually, I'd like the opportunity for the state to, address any of these things. I mean,
Sure.
They came up quick, and they're not beautifully vetted for you. I have to tell you that. I mean, it's pretty quick research.
Oh, I'm not criticizing your research abilities. I know the motions have to be followed quickly.
So yeah, I mean, if the state wants to throw something in there, it may, quite frankly, be very, very helpful in resolving this.
All right. All right. I think we've discussed all the legal issues. I mean, obviously, the self-defense I think is not an issue at this point because we've already moved on that. State, I'll hear from you on the motions. As you just heard, they're sort of all intertwined.
Yeah.
State, you want to try to tease them out, feel free. But
Yeah, I understand. Look, let me just start with kind of the progression of our assessment of Mr. Violette and how we got to this moment with respect to his condition. And this clearly, isn't unusual. I mean, think in terms of a domestic violence case involving serious trauma to a victim. It's very frequently a fluid situation from beginning, middle, to the point of literally testifying about where a victim comes down in terms of their capacity to go back and revisit the trauma that's at issue and to talk about it in detail. We have had and frequently have cases of domestic violence involving serious trauma where we find ourselves in similar positions. And we make decisions about whether to go forward with, quote, victimless prosecution. And victimless prosecution, I have never seen it serving as a legal basis to invite inferences with the missing witness instruction. So more specifically to this case, I'll say that, or disclose that, right from the outset, after Mr. Violette was released from the hospital, police approached the issue of when and how to talk to Mr. Violette, who had been in, for periods of time, a coma. We heard when investigators went up there, he was in, quote, no condition to make a statement. And that issue was revisited, and I believe the police reports and discovery indicate a few attempts to go and talk to him where he simply turned the police away. And that ultimately investigators turned to the CAC process. That process was explained by Detective Danny, who indicated, when we have certain victims with children, for instance, go to the Children's Advocacy Center in order to make statements in a certain environment with certain trained interviewers with techniques that are designed to address, for instance, the sensibility of children who have endured violence. But that is not exclusive to children. We frequently use it for domestic violence. And we used it here, given Mr. Violette's experience. It generated a CAC. Then over time, and obviously we don't press witnesses during the pendency of, say, the 8-9 months of a case and constantly revisit their testimony and their experience over that time. In normal fashion, we approached Mr. Violette, I think within a reasonable period of time prior to trial, and it was clear to us that he was in a traumatized state, but not one where I was going to abandon hope that he would be able to testify. That it has been my experience over many years dealing with witnesses with trauma that it's fluid and there's a step-by-step approach. And at one point, he was able to disclose to us that his intention to testify. I'll say that during the course of trial, that the trial itself has been traumatic. That the turning point was, as I understand it, Mr. Violette actually watched on the live stream the body camera of Sergeant Hurley. I think you can recall was in fact a very real-time experience of him dying in the street, and he watched it. It was Hurley packing his wounds. It was Hurley putting fingers into bullet holes. It was watching blood drain from his throat. And maybe that was ill-advised. We didn't know that he was doing that. He had every right to do it.
Understood. And I went back and thought more about it after. I know I gave you a look when we talked about that at the bench, and I was not thinking the victim's bill of rights at that point in time. It doesn't have to be supposed.
And so, well, he wasn't sequestered. My understanding is he watched it, literally on his phone down the hall. But my understanding is he went from there to a very acute state of PTSD. My offer of proof, and again, I haven't sent out an investigator, but that he sealed his windows, closed his curtains, and was in a non-communicative state, a state of high distress. We had revisited that with family members.
I'm sorry, Counsel.
The source of our information was Angela.
Thank you.
By the way, the state of the record is, I asked without objection, what's his current medical state? It is still fluid. He went to a orthopedist last week that surgical requirements are continuing to unfold. But I also ended it with, how's his mental state? Because he goes into depressions and he has extreme PTSD. And I did not go into the details of how that manifested or how that manifested that week. But I just offer this as maybe not a substitute for Dagny, but just as an explanation for the sequence of events that got us here to Friday. I had some contacts with him in our conference room. It was very clear to me. I reached what is a subjective determination, no, not with the benefit of his physicians or treatment providers, but that he was not in a state to present testimony in this case. I concluded it in terms of what is akin to a medical issue that is trauma-based, not recalcitrance, not being reactive to the interests of the case itself, but simply to his current mental state. And that's what I got. And I've told you that we have been making efforts to get a summary letter from his physician, his provider, concerning his heart condition, concerns about this protracted trauma and revisiting the trauma in this type of detail in an adversarial process of what that translates to in terms of risk. I don't have that yet. That is a work in progress, but I'll concede to the defense. No, we don't have the conventional Gagny. We have a witness, as I've described, that's gone through by the way, not surprising given what we've seen and know of his experience, a escalating traumatic response to evidence that he's heard, to my efforts to have him revisit this for purposes of testimony. And this is where we're at. I am not going to put this human being on the stand on my needs. And I'll accept the consequences, but let's get to the consequences. I don't think there are any as a practical matter, because this does not fit as a matter of law. First, the missing witness instruction, and particularly in the context of mistrial. The missing witness instruction, as the court noted, Ramos did indicate that it had to do with a kind of a concurrency, a balance of access to a given witness. I want to point out that when the defense filed a witness list, the last witness was every witness on the state's witness list. And that's expressed, and I get that as kind of this insurance policy. But bottom line is, Mr. Violette was not released from subpoena. In theory, the defense could call the witness, and I get why they would not, having more to do with, and no offense, or I'm not trying to be provocative here, but bad optics for a case where the defendant inflicted the physical and emotional injury, then put him up as Exhibit A of somebody who can't, address the facts here. I get the tactics of it. But I think what we really need to do is then talk beyond. Both sides could call him. at their peril, and that applies. And so does that automatically take it out? I'm aware that the First Circuit takes a slightly different view federally of this generally predisposed towards one side or another, but it doesn't end there. That's not the end of the analysis. The analysis from courts generally goes on to other issues like, is there a material aspect to this witness's testimony? Answer, sure. Yes. But the most significant issue here is twofold. One, what's the reason the defendant isn't appearing? And I think I've just addressed that. It's trauma-based. I think your comment on homicide and, for example, victimless prosecution of domestic violence is in fact on point for the reason prong of the missing witness instruction. There is a reason here. It's not just fickle. It's not unknown. It's not just a decision to be obstructive from the witness. We don't have that in that case. And, it's not a witness standing up saying, you know what, I'm not going to give the defense the benefit of tactically advancing interests against me in a civil or criminal case. Don't have that here. The fact is that it could apply to homicides and domestic violence victims, but it doesn't based on the reason analysis. Just to dismiss homicides as just, that doesn't make any sense because they're dead and unavailable. But what about all the body of evidence that, preceded the death? We can't get that in many instances. A consent case to high-risk behavior, the defense raises a consent defense to the victim was deceased during this consensual encounter, and therefore it's a negligence case and not a first-degree murder. Defense doesn't get an instruction that says the decedent isn't here, therefore you can infer that she consented to this high-risk behavior. It doesn't work that way. Because that is not the spirit or intent of the missing witness instruction. So I do think there is a general guide to the notion of unavailability in that sense, the availability of that evidence. And that's the reason base. We're not there. He's not dead. But he's traumatized as the basis. But most importantly, let me just address what the core of our argument is. Almost all courts that I'm aware of, and by the way, I think I've conceded that my research has been somewhat compromised, but cumulative evidence. Here's the issue in this case. It's so narrow in terms of what the defense has ever claimed and the state's concessions about what's missing from this case. The defendant's actions, not missing. We don't need the defendant to say, here's what I did, and here's what the defendant did. It's on video from 4 different perspectives. We've lived that all last week. And so the actus reus element of this particular offense is fully established. He could get on the stand and said, I looked out the window, I saw it snowing, and I saw the defendant plow. That's all there. We've heard that from 2 other witnesses and 4 videos. Then I went outside and I confronted my neighbor about the snow. We've got that. The issue is the use of force. We've got that. The issue that the defense is saying that we no longer have is the ability not to establish verbal confrontation. The state virtually conceded it in opening statements. That quote that Attorney Sisti read from me in opening was from the defendant's claim. If you move that snow over to my driveway, I'll kill you and your family. Isn't from Kyle Violette, it's from the defendant. He repeated it 4 times during his interview, without change, without reference to his daughter, always a conditional threat. That was what I said in opening. And, you're right. It wasn't because I knew he wasn't going to testify. It's because I started to have concerns. And I didn't want to anytime I can avoid a credibility contest over certain issues and focus on, if this happened, and we'll accept that it did, we still win this case. That was that opening. I accept. I accept tactical criticism from all my work, but I did, and I consciously did, a defendant point of view of this self-defense case to say that even from his perspective, the state wins, because this was there was no imminent use of lethal force, no reasonable force, and that's the issue here. And so the defendant, and by the way, I'll make this offer proof. The next witness coming on, Garston, we anticipate putting on the defendant's claim of what these threats were, and without impeachment. What he claimed happened next is in sharp contrast to the video, and we'll point out, everybody's been pointing out that, hey, you can't hear what was being said there. We've adopted from the outset that the defendant's claims about what Mr. Violette said will live with. As an aside, do we have countering evidence of that? Did Mr. Violette say something contrary? Yeah, he said a reduced, intense version of that. But so what is left for the defense is simply to say, I want to put him up to impeach him, to say, oh, you said that you went out there to not have a deadly confrontation, that you said something to the effect of, if you continue to, if I could be direct, fuck with my family, I'll fuck with your family, something along those lines, a slightly diminished version. Our approach to this has been, so what? And that's the heart, then, of this missing witness instruction, is that due to its cumulative nature of the evidence, the one side should not be able to invite the jury to speculate that it was something else. What exactly? That he did say, if you put snow in front of my driveway, I'm going to kill you and your family. I mean, we're already there. So that makes it about as cumulative as you can get.
Can you respond to the defense's argument that if we had known in advance that that this was going to be a victimless prosecution, so to speak, that we would have done different in our opening, we would have approached voir dire differently, that it's unfair to the defense because they didn't know this is going to be a victimless prosecution situation? What's the state's position on that?
Two issues. Then let's get to, I think, which would be the mistrial analysis. We would have done things differently. The mistrial motion, notably, at least I didn't see it, invoke the actual standard, which is manifest necessity. We're dealing with a standard of prejudice, of unfair prejudice, that is such a degree that the defendant's very basic rights to fair trial have been compromised. And what they initially raised in the motion is, we would have made tactical decisions differently. Tactics don't rise to quite that level. Tactics change. I think the court is well aware, we're all well aware doing this work, that it is about as organic and fluid a notion of preparation. Everybody's got a plan until you get punched in the face, and that's what happens here in a figurative sense. And this wasn't a punch in the face in that it's not planned, but witnesses frequently get up on a witness stand and say something different than you anticipate, and your tactics change. That's kind of the situation we're in. Although, I'll concede that this is of a degrees matter, and still, this isn't one fact deviation. This is a central witness. But the differences in terms of what Mr. Violette would testify to, again, I've already gone over the cumulative nature of it. Walking out of his garage, putting on a shirt, approaching Mr. Violette, getting face to face, walking away, walking back, seeing a firearm be produced, turning away, getting shot, crawling home, being in really a state of dying, are the elements of this offense. Bodily injury, the intent to kill are established by the medical evidence, and the act of this offense is literally documented by video. So what degree of change of tactics are we talking about has to be measured and assessed in light of the actual evidence in this case. I was struck by the notion of, in voir dire, I think the quote was something like, we would have been telling the jury what to do about that. But that's not voir dire. We don't get to get up and tell jurors what to do during a case in voir dire. I think probably both sides pushed up against that line a little, as is the practice, particularly in this county. But that doesn't change, what you're able to do in voir dire. You're not supposed to be able to bring in case-specific issues of that kind of degree and ask the jury to, hey, get prepared to respond. That's opening statements at most, and even opening statements shouldn't be making argument. Opening statements can raise issues. And obviously, if they had known that he wasn't going to testify, we both would have changed our tactics to address that, what is now something of an elephant in the room, but one that's really, frankly, overstated, as I say, given the margins of evidentiary and factual disagreement between what Mr. Violette would say happened and what the defendant has said happened. And that's, one, eliminates the missing witness instruction, and two, I think forecloses a mistrial analysis in this particular case. To summarize, this witness is not peculiarly available to one side. Both sides could call him. There is a rational reason other than obstructing the opposing side from obtaining evidence. And this is fundamentally cumulative evidence to the extent that it deviates from cumulative in the actual statement that is made, favors the defendant at the outset of this. That is, we're put in a position of conceding that point, which we more or less did at the outset of the case.
Thank you. What's your response to that?
Yeah, I appreciated that argument, and I think that we're starting to focus in on some very important points. One, again, we don't accept the offer of proof with regard to Kyle Violette presently being so traumatized that he is the equivalent of a dead person and is unavailable. Okay, so I just want to make sure that we're clear on that, because there hasn't been any competent evidence adduced at any hearing to support that factual allegation. I want to be extremely clear on that. And two, it also opens up a can of worms, because if the state had been dealing with Mr. Violette over time, and they came to a conclusion that he had some significant or substantial psychiatric condition, that's something we're supposed to know. That's something we're supposed to know, so that I can bring that to the attention of the court, and I can say I reasonably believe, under Gagnon, that there's an individual that may be suffering from a disability or a mental defect, and I want the court to take the material, if it exists, and review it so that I can have relevant portions of that particular report or reports, so that the court can make a determination as to whether or not it's exculpatory, just like Gagnon, whether or not it's material, whether it's something that the defense should have. None of that was brought to my attention ever over the past year. None of it. We didn't know that he was in some kind of counseling. We didn't know he was. I don't know.
Okay, I didn't hear the state say that, and I do want to just reiterate, to the extent in my questioning to you, I think I made it sound like I think I overstated my understanding of the evidence in this case. And what I heard the state say is that they understand he was having emotional difficulties, but I didn't hear anything about counseling or treatment. Or am I missing something?
No, but I did represent that we're trying to get a summary from a physician who talks about his PTSD and both the physical and emotional aspects of this. And again, you've heard admitted evidence from Angela that he's suffering from extreme PTSD, and that was, without objection, it is the state of the record.
Okay, Attorney Sissy, continue. Yes.
It's the state of the record, but where are the documents? Where's the background? And if you knew that prior to her taking the stand, if you knew he was suffering from such a condition, why didn't the defense have that material? Why didn't we have that before the court? So the court could vet it, go through it, and deal with it and give us those documents that the court deemed that we should have gotten. This isn't after the fact analysis. This is something that should have been taken care of well in advance of last Thursday. It should have been taken advantage. We should have taken advantage of that well in advance of the start of trial. I mean, if in fact the victim witness advocate in this office, all right, knew that there was counseling or there was a physician involved or some kind of psychiatric analysis, how about just a declaration that in fact he was suffering currently of PTSD, which we did not know. All right, guess what? I would have been filing the motion. Any defense attorney would be filing a motion to determine whether or not there's something in those counseling records that would have exactly gone to a defect or a condition, or whether it would be impactful with regard to credibility, the ability to accurately recollect. I mean, all of those factors. But, if this thing is sprung out of nowhere, and it's just an acute thing, and there's no anticipation anything like this would happen, that's one thing. But right now we're hearing that that's not true. That there's been a concern for some period of time that hasn't been communicated to the defense or the court. That's what we're hearing. And that's a problem. That is a fundamental rights problem that was decided in August of 1992 in Gadney's case. That goes to the heart of being able to be on the same level with the prosecution in examining witnesses and getting information and making sure the court vets it properly so that we can come to court and cross-examine properly. Now that wasn't disclosed. And I want you to add that to the motion for mistrial as well. That was not disclosed. So if we're standing here at 11:28 on Monday, the 17th, and he's suffering from a psychiatric condition that we don't know anything about, that the defense doesn't know anything about, that amounts to cause in and of itself. I mean, that's material that would have been used during voir dire. That's material that would have been used during open. I mean, we're discovering now. So, with regard to his mental condition, one, we deny the offer of proof. Two, if in fact there is a condition, we haven't been supplied with that information, we make that demand now. I can make the offer of proof that we never got anything like that. And if we did, you would have had a motion before you so that you could review the psychiatric records and determine whether or not they were material, exculpatory, etc., in compliance with GAG. So please add that to it. And
Okay.
we also state that the state's voir dire on March 3rd, 2025 got into serious bodily injury, threat of serious bodily injury, threatening, deadly force, self-defense. Let me assure you, Your Honor, if this was a victimless prosecution, that is an area that would have been delved into as well. Not only for the state, but of course for the defense. And we never got that opportunity. So voir dire is very important when you're selecting a jury so that you can properly vet for what you anticipate is going to take place during the course of trial. So we were denied on voir dire psychiatric material and the ability to discuss a missing witness if in fact that would have been dealt with prior to trial. And quite frankly, it could have. We could have been addressing all of this prior to trial. But Friday came along, and again, unless it was a complete surprise to the prosecution, then I would state that the defense has been cheated out of an area that we could have delved into and dealt with on voir dire and open. And in fact, it would have changed certain categories of where we would have gone. Now on, how about Judge, that would have been part of us asking the court not to allow, all right, that video to come. Right. if he was so destroyed by something like that, if we had information that something like this would have triggered him, do you think it would not have come to your attention? I argued that it was prejudicial, much more prejudicial than probative. I think the court would have started tipping in my direction if I also could have played the chip that it would destroy the alleged victim in this case and render the alleged victim incapable of testifying in trial. But I didn't have any background on that. I didn't know. I know that Court TV was certainly recording it and running it live. I also know that the alleged victim probably has a television set, and I would imagine that he's probably watching it. In fact, he may be watching it right now. But what I'm saying, and there is no sequestration of an alleged victim, and we all know that.
Right.
So I think that would have also come into play. All right, or it may have, but it certainly would have been part of the argument. But again, the voir dire was part, and then the opening, so you're devoid of mental health information. That they were devoid of a missing witness possibility. They were devoid of all of that now has become real. It's part of the case now. We're talking about it right now at 11:30 instead of on the 3rd of March, instead of on the 12th of March. We're talking about it now. That's not the way these things are supposed to be running, and that goes to the mistrial aspect. That's the problem. It's only going to get worse. I mean, if I ask you now, will you order all of the psychiatric and medical evidence with regard to Kyle Violette, and 15 minutes from now we get a stack of it, and it's got psychiatric material in it that should have been given to us, we all know where the case is going. Right? I mean, is this after the fact, or am I supposed to find out about this stuff next week? Is Jason supposed to become, somehow finally knowing what the case is about after it's tried? No, all this stuff's supposed to happen beforehand. There's a significant disadvantage here. But I have to say, I go back, we'll go back to Ramos now for a second, okay? I want to go back to that because I have this almost vivid recollection of that case. I know exactly where it happened. It was in Manchester. It was on the west side. All right. It was an awful situation. And Ramos, in that particular case, you'll see there's a real clear indicator in that case as to what the facts are. There's nothing like this. I mean, there's nothing like this. I mean, that was not a witness that was particularly aligned with anybody. This particular case, there clearly is. And to say, well, the defense could call that witness is insanity. I mean, that's an alleged victim who has a completely different look upon this case than we do. And it was posited that he was a victim. He is not a victim, okay, as far as we're concerned. So, I mean, right out of the gate, we have different views of what's going on. And we look forward to his testimony. Because, quite frankly, when he did have that little soft interview with the CAC people that was witnessed by the detective in this case, he downplayed it like he was just going out there to say hi to his neighbor and please don't, put snow over on my driveway. That's not it. That's not what happened. And he said more. We would have adduced more than a conditional threat. And in fact, we stated there was more than a conditional threat. We took issue with that. Not only was there a threat directly to Jason, but you heard from his daughter the other day, there was a direct threat to her. She heard him say, I will kill you, and I will kill your daughter. And we were much more prepared to go into a lot of other areas, but he's not here. They're not going to call him. All right. If we would have known that, certain things would have been produced in different ways. But all I got to say, Judge, is this is a unique situation. I have never been thrown into this at all. And you've been practicing a long time in a lot of different jurisdictions, and so have I. And so is Attorney Barth, so Sarah. I'm just saying, unique situations have to have unique conclusions. And going forward now, with the specter of a psychiatric problem from a witness, and the base of the missing witness is that he has some kind of a trauma that hasn't been explained or delivered to the court or to the defense in the form of any competent medical evidence, that's not going to cut it. I mean, that's way off base.
All right, thank you. Speak to this Gagney.
Yeah, yes, I do. I think this is a, sort of a confabulation of Gagney with one prong of the missing witness instruction, which is availability. Gagney would be, look, there's a criminal event or an accused criminal event happened, and there are issues about actions, perceptions, behavior in the course of that criminal event. And Gagney is a discovery mechanism to revisit generally speaking, a witness's, particularly a victim's state of mind, condition, during the course of charged conduct is our standard application of Gagney. That's different than saying, look, a witness has an emotional reaction predicated on issues that happened during the criminal conduct. There's nothing here where we're saying, Mr. Violette walked out of his house and engaged in certain conduct because he had PTSD, and therefore the defense should have records to assess that claim about the offense conduct. That's Gagney. This is literally a fluid situation on the eve of trial where revisiting these issues has had a consequence to a deeply, seriously injured person. I made an offer of proof about his witnessing that medical interaction with Hurley. Let me just say, these notions of the defendant's objection based on prejudice have nothing to do with this. The jury, there's no member of this jury that was lying on the street dying from 6 gunshot wounds in that scene. It was only Mr. Violette. And he has every right to view that material, whether it was from court television or our own expectation of presenting it as evidence. He had a right to see it. He did see it. There was a consequence. You don't want to accept that offer of proof. I get that. They're just simply declaring, I don't want to accept an offer of proof, though, isn't the same. It's State versus Dodopoulos, I think, where the court has commented on offers of proof at a bail hearing. When's a defense entitled to more? I think the court needs to make a finding that there's some basis in the context of this particular analytical framework, which is different than analyzing a victim during the course of an offense, and whether or not you need more to make a decision about the missing witness instruction. And that, again, I'll repeat that the Gagney framework isn't a necessary component for you to make the decision about the availability of the witness. And if this is contrived, this witness is not uniquely available to us, not willing to waive, for instance, a spousal privilege just for us to advance our case. This witness is available to the defense to call, certainly at their peril. But this prong, I think, is being really misstated in terms of a Gagney discovery type analysis. I'll return to this. The impact of the absence of testimony. They are claiming, on the one hand, that what he would have recast fundamentally is whether or not there was a direct threat, because the defendant, Jason Levesque, has always said there was a direct threat, and his daughter got up here and testified there was a direct threat. That's just not true. Daughter got up and testified, I heard something about the snow, and then I heard a threat to me and to Jason and his family. That was a condition. This is the threat. And by the way, Jason Levesque gave a detailed statement the night of the offense repeating the threat, probably 5 or 6 times, all stating a conditional threat. And so what the defense hasn't been able to do here is say, if only Kyle Violette were to testify, we'd get exculpatory evidence out. And they've never made that claim, not in their motion, not in their argument, not in revisiting the impact of prejudice here. He would have got up and delivered to us that it was a direct threat. There's no offer of proof. There's no basis to say that. It doesn't exist. And so what they want to do is put him up, have him say that it was a lesser threat, and then by just comparison impeach them. But what they can't do, for instance, is say, Mr. Violette would have claimed that he had a weapon, for instance. There's no weapon found at the scene. Mr. Levesque has never claimed there was a weapon at the scene. Didn't say, nobody's claiming, what he would have said is, I've got a weapon here and I'm going to use it, and brandished it. We see on video that he isn't brandishing anything. And Mr. Levesque has never made a claim in the course of that interview. In fact, he specifically disavows it. I could see his hands, didn't have a weapon. And so where is the exculpatory evidence that leads to the notion of both prejudice and fair inference? If the court is going to give an instruction on missing witness, there's another ground, and it's in State versus Rubo, R-U-O-B-O. And I suffered through that case on the defense side of things. Didn't work out well. But there it was the court made the neutral missing witness inference, which is, hey, look, this witness is available to both sides. In reality, not. He had a Fifth Amendment right not to testify. None of that addressed in the Supreme Court case. But the implication was, look, you don't speculate, and that's the go-to rule for absence of evidence in criminal cases. I mean, what are they invited to speculate on? That he was waving a firearm around? It's demonstrably false. Can't speculate about that. Other issues that are provable because of the video and because of substantive statements that the defendant has offered, which we're about to put on into this trial. So, in the absence of exculpatory evidence and an absence of fair inferences adverse to the state, the missing witness instruction without the neutral instruction is inappropriate.
Can I just follow up before you get to that consistent? Back to this offer of proof question.
Yeah.
And I don't want to push you too hard on your trial preparation and all that, but what I understand you to be saying is that the witness was here.
Yes.
Do I take it to be that if you had told the witness you must testify, I'm going to put you on the stand, was he saying he would not, could not? What was his position, or can you tell me that?
Yeah, look, I get that some of this is work product. And
I don't want to get into that.
Look, I'll just be transparent. I think these arguments in many ways are fair in the sense of asking for the reality of this progression. And let me just say that, everybody had a concern. I mean, looking at these videos, here's a guy. I've had the same concerns in every domestic violence case where I see a photo of often a woman with serious injuries with someone that, it creates additional trauma that's non-straight trauma. From the beginning of that case, I wonder whether or not they're going to be able to testify about it or willing to testify about it. Right. So this case, we clearly had our eyes on from the get-go. I've described that progression of police going out to his residence, being declined interviews, and eventually agreeing to be wheeled into on a wheelchair into the CAC, by design setting to address situations like this. Then, closer to trial, reaching out and visiting him. He's clearly in a state of distress, not one where I concluded he wouldn't testify. Not one where I concluded he would not testify.
So you're saying he would have if you...
At a certain point before trial, our assumption was, look, we're going to just get him here. He was under subpoena. He wasn't running away. Then it got to the point where he was starting to appear quite distressed. And at one point said he could not testify, would not testify, and then received a communication that says, no. He's going to testify, he's able to testify. In other words, this was not linear.
Right.
And so after that, it was this oscillation during the actual trial period where he was clearly being affected by the process, by revisiting evidence, and at no point, though, can I go back and say, geez, we reviewed documents about his treatment for PTSD. That simply became apparent to us during the course of literally ongoing trial preparation, during trial, you know? And I think that's fair to Mr. Violette. I certainly, you know, want to characterize this appropriately on his behalf. He deserves it. But on the other hand, I get the feeling that this is somehow a late-stage sandbagging effort. It's not. You know, I thought our disclosure was appropriately timely in that, hey, this is it. And by that point, it was, you know, Friday afternoon. We got to put him on or not? And it was not.
Right, and I guess I don't mean to push back on this again. And I'm not trying to suggest you're sandbagging. I'm just trying to make sure I understand the facts. When you got to Friday and the decision was we can't put him on, that was my understanding. That was your decision. Do I understand that correctly? Or
yeah, my decision, but his statements by that point was that he was not in a position to testify. We revisited it, or we more broadly inquired with, say, Angela, and said, look, he's a wreck in terms of responding to, I think I've mentioned the body cam image of him dying in the street in front of his place. And so I feel like we took necessary, appropriate assessments, both with him, no, can't testify, his wife, he can't testify, but we don't have, you know, some sort of PTSD evaluation and some clinical assessment of consequences to his medical and emotional well-being if he were to. I don't have that.
Okay, so I'm just trying to make sure I understand, because I think there's a distinction between saying I, as the attorney, sort of made the decision that I think this would be bad for him, or on balance would be so harmful to him that I wouldn't want to put somebody through that. That's a different factual scenario than a situation where the witness is basically telling you, I cannot do this.
Both.
Okay.
I mean, I've had plenty of witnesses who have said, I can't do this, and we do a approach. Let me ask you this question. Get an answer. Let's do it in the courtroom.
Right.
Get an answer. What do we do? It's sitting down. Get an answer. We didn't get there into a progression of a highly traumatized victim. We've all been there.
I understand. And again, not trying to intrude on your work product, but were you able to do sort of, I don't know if you do this or not, practice sort of directs with him? Was he unable to do that? Was he unable to do that?
Yep.
Okay.
I would pose certain questions, and I concluded that he could not sustain an inquiry about the actual events.
Okay.
And I'll return to this. You can find, if he's not unavailable, then by definition he's available to both sides. They can go ahead and call him, go through this exercise on their own. But I'm not in a position. I agree to offer what I would consider to be conventional evidence of here's a declared unavailable witness by virtue of this analysis from a qualified third party.
Right.
Not that as lawyers assessing an ability to conduct an examination doesn't bring some, I think, appropriate perspective to this. But I agree that this is a kind of a hybrid situation. My representation is I could not and will not call him. If the court concludes, by the way, for purposes of this analysis, that that's insufficient to declare him unavailable, I say, fine, put him up.
Okay. Thank you. Attorney Sisti?
That opens up other avenues, doesn't it? Opens up avenues like just what material did you have to come to that conclusion? What exactly were the specific conversations?
on and on. I mean, again, I want to make sure that my position is unshakable in that we don't accept the offer. We just don't accept it.
Well, I
It's
mean,
not-
you're not questioning Attorney Barth's representations about what his conversations with this alleged victim? You want me to not accept counsel's representations as to a conversation he had as an officer of the court? You think I should not accept that?
I think that he's opened up for you and invited you to go into the specific conversations. Yeah, I think he has. And he's invited us to do that.
Oh, I see.
But what I'm saying is, if it was 13 seconds of this, what we just heard, then no, I don't accept that. I'm sure it was much more. Okay? But the other thing that we also heard was we shouldn't speculate. And yeah, we shouldn't speculate. And if you're going to come to a conclusion of whether or not somebody's like medically in a trauma, all right, or psychiatrically unfit, it doesn't come from people with JD degrees. It comes from other people with specified medical or psychiatric training. And we don't have that. That's not before you. You can't just accept that. I challenge that. This is not a bail hearing, okay, with offers of proof. In fact, in bail hearings where there's offers of proof and you make a representation that somebody's mentally unfit, well, then usually you make that representation because you reviewed a certain document. I mean, you understand that, right? You don't just say, well, I'm making a decision, I'm not going to call. I'm not going to call. It would be inhumane to call. Right? That's not the test. The test is on unavailability, you're devoid of critical information to come to that particular conclusion. You were on the right track. What you're really asking, Attorney Barth, is whether or not it was tactical, right? Whether it was a prosecutorial decision, or whether or not he just declared him not a witness anymore. Maybe because of good reason. Maybe because he felt bad for the guy. Maybe because he wasn't acting perfectly okay. I wouldn't know that. I wasn't there. Because he's not equally available, quite frankly, to us. He doesn't come to my office. I don't have people that were reaching out to him. We were totally off limits. Let's keep this thing on the right tracks. The availability, all right, is clearly leans in the direction of the prosecution. They were with him Friday in this building. He appeared Wednesday. He appeared Thursday. He was with them Friday. So how can you come to an unavailability? He's responding to a subpoena. He's sitting down with the prosecution. He's discussing the case. He's discussing what he saw on television. Sounds like he's pretty cogent there. Right? Sounds like we're having quite a discussion in a courthouse where there's a courtroom where there's a trial going on. Right? And he's not here. And I didn't hear that he just flat out said, look, I don't care if you call me, I'm just not going to testify. I didn't hear that. I heard that there was probably a decision that was made by Attorney Barth. I respect his decision. But again, it's one that you can't just accept and say that now he's unavailable, okay? You can't make that connection. We never had the chance to even challenge that. And you know, if you're going to say he's like an incompetent witness or something like that, the presumption is he's competent until you can find him otherwise. Right? I mean, that's a basic 602 rule. There's nothing to that. But what we're dealing with here is speculation. You're speculating that he wasn't able to testify. You could have brought him in. You could have questioned him. You could have questioned him. I mean, it's one of those situations where it's not even adversarial. It's up to you to determine whether or not he would be a competent witness at that point, not the prosecution. It's up to you. And that's part of the rules of evidence. But if they bypass the rule of evidence and just pull the plug on the witness, then it's up to them. Then it's up to the state. Then it's their decision. And if they're making a decision like that in the last second before the weekend, when the case is almost in, other than him and one other witness, then, you know, we should be getting some notice on this. And again, I'm going back. This isn't some, and I don't think frankly, I don't think the prosecution is trying to sandbag us. I don't want that impression to be made at all. What I do want to make the impression of is that there were other things for us to do in this case if, in fact, this issue, okay, would have come to our attention. And if it came to the state's attention that he was having a major mental problem prior to trial, that's something we're supposed to know. That's something you're supposed to know. That's something we're supposed to work out before we swear a jury. I mean, in all fairness, and it's one of those words that really is kind of overarching here. We were denied that opportunity. I was denied that opportunity Friday. I don't know where he was. I mean, when we went to the bench, I don't know if he was in the courthouse or if he was at home or at a counseling session. I have no idea. But I mean, it's too late. The horse is out of the barn. And if there's unanswered questions about him and whether or not they should have declared this situation earlier, then it's too late. We can't put it back together now.
Counsel, for the state, anything further you want to add?
Yeah, I just, again, want to reiterate that there's a difference between finding a witness incompetent and unavailable. I can go into greater detail. I suppose in my interactions, no, it wasn't this lucid. So how do you feel today? Feel like testifying? No, not really. That's not what's going on. But again, if this will take literally an evidentiary hearing to satisfy the defense, I don't think that's what the analysis is in this instance. It is a representation that we are not calling a witness, and the defense has decided, likewise, a witness on their witness list. They're saying they're not calling. I guess at that point puts it just as this unavailable witness, and you go to a second-tier analysis, which is what's the nature of this evidence? It's cumulative. What's the representation about his absent testimony? It's not exculpatory. You haven't heard that. Just that we would have made sort of unspecified tactical decisions differently during voir dire. I'm not sure that's appropriate. And that certain statements that I made came from the defendant, simply not true. Came from the victim, that's simply not so. I think we're left with a more conventional missing witness analysis than this Gagne incompetence issue. I have offered by way of explanation, but it's not what the state rests on. We're not calling him. Defense isn't calling him. They shouldn't be allowed to invite speculation through a legal instruction.
Okay. I'm going to take these matters under advisement. We're currently scheduled to start at 9 o'clock tomorrow morning. I'll work on doing my best to get an order out later today so that you all know where we're headed. And
can I just, to the extent that it is even relevant, we are getting communication from our victim coordinator that a doctor is issuing a letter today. I don't know from what. I don't know that we'll even submit it, because my analysis is that we're not here to prove that he's an incompetent witness. But I'll wait to see when we get it. If the court wants it, the defense wants it, we'll obviously provide it.
do you know which, from his GP, like from a general practitioner, from a...
Your Honor, I can represent to the court, it's my understanding that this is coming from a physician that has been, I believe, involved in the victim's care for quite some time. I don't know if it's the only physician he's been seeing since the residual, since the incident occurred, but it is a physician that he has been seeing.
Okay.
Well, I mean, and I'm asking too much to assume, but I want all of the medical records. I want medical records, I want the psychiatric records.
What I'm hearing from the state is they're not aware of any psychiatric records, they're not aware of any psychiatric treatment, they're not aware of any counseling treatment. Am I correct about that?
That's correct.
All the above, and that we object at this juncture that it's not an appropriate Gagne proceeding. If the defense wants to file a Gagne motion, we'll respond.
Yeah, we will, because you referenced specifically that PTSD, from what I understand, is a physical condition. It is a psychiatric condition. So that's a good faith representation on my part to ask for his mental health.
I can represent to the court, it's my understanding this letter we'll be receiving is going to include some information, potentially an explanation for that. Again, it's not from a mental health professional, but that the letter that we anticipate receiving will likely address that in part. But again, we have no knowledge of counseling records or any specific kind of mental health treatment that has been referenced.
All right. Obviously, I would encourage you to share it with defense counsel when you get it. If you decide it's something you feel the court should see, if either side feels it's something the court should see in making its decision, please get it to the court as soon as you can. Otherwise, I'll try and get an order out. Thank you all very much. Appreciate the arguments.
Just to request practically from the court, Your Honor, since we're still dealing with some technological issues downstairs, if it would be possible to in some way alert the office to pick up a copy of it, of any order in person. I know we'll be here.
We'll get it to you.
Thank you. I just wanted to make sure we're all on the same page.
We'll get it to you in paper.
Old school, but works.
Appropriate 19th century technology.
You can send it by carrier pigeon, but I don't know that it'll get lost.
Thank you all very much. Well, thank you.